Hi, everybody. Good afternoon or good evening, depending on where you are joining us from. I'm Ann Cleveland, the Executive Director of the Center for Long-Term Cybersecurity here at UC Berkeley. And at the center, our mission is to help people anticipate and address tomorrow's information security challenges in order to amplify the upside of the digital revolution. Today's event is an inaugural event in a speaker series on data scraping that we are hosting over the next few months. Data scraping is interesting from a cybersecurity standpoint, of course, but it's that and it's so much more. So along the way, we'll look at different facets of the issues that emerge when data is scraped at scale. These include legal, technical, policy, governance, and ethical issues, among others. So we hope that all of you will continue to join us on the ride over the next several months. But we couldn't have two better guides to launch this conversation than today's speakers. I know we will all be just a little bit smarter after hearing their thoughts on one aspect of the data scraping question, data scraping and the courts. So I'm very pleased to introduce our moderator, Tejas Narechania, who is the Robert and Nancy Corson Assistant Professor of Law at Berkeley Law. His work focuses on telecommunications regulation and intellectual property, among other subjects. He is also the faculty co-director of the Berkeley Center for Law and Technology. And before joining Berkeley Law, Professor Narechania clerked for Justice Stephen G. Breyer of the Supreme Court and for Judge Diane P. Wood of the U.S. Court of Appeals for the Seventh Circuit. He has a JD from Columbia Law School and also is a Berkeley alum with a BS in electrical engineering and computer science and a BA in political science. So welcome, Tejas. And our distinguished panelist today is Orin Kerr, also a law professor at Berkeley Law. He is one of the country's foremost scholars of the Fourth Amendment and criminal procedure. He helped found the field of computer crime law, which studies how traditional legal doctrines must adapt to digital crime and digital evidence. Orin has authored more than 70 law review articles, over half of which have been cited in judicial opinions. He is a former law clerk for Justice Anthony M. Kennedy at the Supreme Court and a former trial attorney in the criminal division at the U.S. Department of Justice. Prior to joining Berkeley Law, he was a professor at the George Washington University Law School and later at the University of Southern California Gould School of Law. So welcome, Tejas and Orin. I'm going to turn it over to Tejas to get us kicked off. And we always invite our guests to just share a little bit of background about what you're working on and also what drew you to the field. So over to you, Tejas.
Sure, maybe I'll take a quick minute to talk about what drew me to the field because it's so intimately connected with the work of CLTC. So as Anne said, I am a Berkeley alum. I spent my formative years as an undergraduate at Berkeley thinking that I wanted to be a computer scientist, but quickly drawn to the sort of more societal questions of technology. How does society shape technology? How does technology shape society? And that was that was in part because of Professor Steve Weber, who I think helped found CLTC and make it the institution that it is today. So I am proud to say that I was Professor Weber's student many, many years ago, and I'm really proud to be a part of Berkeley and Berkeley Law today. So it's that training and that experience thinking about the intersection of technology and society that has brought me today to think about questions of intellectual property, telecommunications regulation, and in particular, and starting to think about cybersecurity in little bits and increments. But Professor Kerr, I know you know much more than I do, especially when it comes to cybersecurity. So maybe you want to say a little bit about how you came to this field.
Well, in 1998, I was hired by mistake into the Justice Department's computer crime section. They filled out the wrong form and were very upset to find out that they had hired me and tried to fire me, but there was no government form to fire me. So they were forced to hire me, and it was into the computer crime section where they were trying to figure out how the computer crime laws should apply. And one of these new laws, relatively new laws at the time, was the Computer Fraud and Abuse Act. And they said, well, what do you know to do? And I said, I don't know anything. I just finished a clerkship and I've never practiced law. And they said, well, we'll give you a bunch of legal questions. And one of the legal questions I worked on was, what do you make of the Computer Fraud and Abuse Act and how could it apply? So I got into it then, and then started writing about computer crime law, including the CFAA, once I became a law professor in 2001. And it's been a continuing journey. We're still trying to figure out what this law means. We're getting there. We're getting a little closer, but it's always interesting to see what the courts come up with.
Yeah. So maybe we should talk a little bit about computer crime, about the CFAA and the courts. But I'll start by framing a little bit of both today's discussion and the series of discussions that's going to come over the coming months. And maybe a good place to start is, to the extent that all of these are about data scraping, it's probably worth it to try to define what we mean by data scraping. So I'm going to look here at the Ninth Circuit's decision in HiQ Labs versus LinkedIn Corporation. And there, the Ninth Circuit defines scraping as, quote, involving extracting data from a website and copying it into a structured format. And then it goes on to say that this is, you do this in order to engage in data manipulation or potentially data analysis. The Ninth Circuit is careful to note that scraping can be done manually, but typically the scraping that we're worried about, or the scraping that we've seen of late, is done automatically, usually through a bot or some sort of web robot. So that's the Ninth Circuit's definition of scraping. And what that means, and I'm going to put this in broad and general terms, then maybe Professor Kerr, you want to follow up, is that we start to see a little bit of the blur. We start to see the line between what's public and what is private, or what feels public and what feels private, blur a little bit. Because LinkedIn's database is public in the sense that we can access it online, but it's private in the sense that it's private to LinkedIn, at least in aggregate. But data scraping makes it possible for someone else to use that public interface to access the massive data, or that aggregation that feels a little bit more private. And that distinction between what's public and what's private, or what feels public and what feels private, is blurred by scraping. Does that seem right to you? Is that a good way to just start the conversation?
Yeah, I mean, I think of it less a question of public and private as that which is thought to be hidden and exposed, which maps often onto public and private, but is a little bit different. I mean, the law of the Computer Fraud and Abuse Act prohibits unauthorized access to a computer, and it can be accessing it without authorization, or the law then draws a separate category of exceeding authorized access. But it was drafted in the 1980s before the web, before you had everyone surfing the web all day, before you had companies and people putting private information up on the web. And so the question of how this law applies to websites really involved asking how a law before the technology was around applies to this technology that just became completely ubiquitous, absolutely everywhere. And courts have struggled with it because you can kind of look at it two different ways. You can say, well, the nature of a website is that inherently it is a publication mechanism. It is all about making information available to everyone without any authentication, without any sort of restriction on access. That's kind of inherently what it's about. And in that case, it seems odd to talk about it being unauthorized to access it, because it's sort of a publication mechanism that authorizes it as a matter of technology. On the other hand, you can say, well, people will often put information up on a website, make it technologically available, but not expect individuals to access it. Maybe it's at a URL that is, no person is going to sort of stumble across on their own. Maybe it is something that they thought was password protected that is not password protected. All sorts of ways in which something that a person might think, well, it's sort of exposed, but as a practical matter, it's hidden away. What do you do with that? Is that an unauthorized access? And that's really what the courts have struggled with over, really, we're now almost now at 20 years, trying to figure out if something is up on a website, but it is collected in either a way that the computer owner didn't expect or want, or in a circumstance, maybe subject to a cease and desist letter, or at a URL that they didn't expect to happen. Is that unauthorized access, or is that authorized? And that's what the courts have really struggled with.
So that's really interesting. And the way the background behind the CFAA and when it was enacted as compared to the internet suggests at least a couple of things. So one thing that you said is CFAA was enacted a long time ago, before the web exists. And now we have to apply the CFAA to this new technological system. So I think I have maybe two questions that come out of that. One is, I mean, this strikes me as a familiar problem of law. We often have laws or precedents or statutes that are in place and that have to respond to evolving technological regimes or new societal systems. So is there anything that is unique about this situation that makes that familiar problem more complicated than usual? And then also, how should we think about the application of the CFAA, the application of this old law to this new technological regime? So kind of a bigger structural question about what's unique about this general problem of law to this situation, and then also a little bit more about this particular question.
Yeah, what I think is unique is that the web comes around like early 90s around, and the Computer Fraud and Abuse Act is 7 or 8 years old, depending on exactly what start date you pick for it. But no one knew what the Computer Fraud and Abuse Act meant before the web comes around. So it's common to say, here's a body of law that's well established. Here's a new technology. How does the old law apply to the new technology? But this was like a legal framework and legal statutory language that was really uncertain. And then you add in new technology. It's not certain how the law applies to the old technology, much less what do you do with the new technology? So you had, for example, when courts started to play around with this around 2001, 2002, you had incredibly broad interpretations of what the unauthorized access prohibition means, especially because Congress, in its infinite wisdom, added a civil remedy to the statute. And then businesses started to use this to get into federal court. They'd be like, well, we have a website, you have a website, you visited our website, we didn't want you to visit our website. Because we object it is unauthorized, we want an injunction, you can't visit our website. And judges were like, oh, well, it looks like that other business, they're not very nice. And so okay, fine, we'll enjoin this conduct, which meant, although the judges didn't realize it at the time, that they were saying that was a crime. And so this is primarily a criminal statute. And so the remedies can get, punishment can get pretty severe, felony liability here. And the judges just didn't realize that there just weren't laid down cases for how to apply the statute at all. And so you have a bunch of, especially some of the early 2000s cases saying, if the company objected to the authorization, well, then it must have been unauthorized, and therefore, it's a federal crime to do what the owner of a website didn't want, which I kind of crazy, but that was at least the suggestion of these early cases. So that's what I think makes this extra difficult.
That's interesting. It sounds like there was very little CFAA law before the internet comes around and before scraping becomes a thing. And to the extent there was any CFAA law, it was bad. Is that an accurate assumption, or it was judges not fully informed about the effects of the potential ramifications of their decisions?
Yeah, I think it was just sort of non-existent at the time, and there were really there are a couple of different concepts of what unauthorized access might mean. So it might mean like breaking through some sort of code-based barrier. There's a technological restriction like an authentication gate, and a person bypasses that by guessing the authentication mechanism or exploiting some security hole that allows them to get in without going through the normal authentication gate. That I think everybody realized that's unauthorized access. That's like classic hacking in the vernacular, and then that's clearly covered. But then there are all these other questions like, what if a person accesses a computer in a way contrary to some express limitation on access. It might be terms of service on a website, or it might be an employee who's told only access this computer for work-related reasons. And then the user does so for reasons that violate the expressed restriction, written or orally expressed. Is that unauthorized access? Like, well, that's a totally different kind of concept, but is that covered? And then there's also just sort of, I think, a broader idea, maybe just you're just supposed to know there's some things you don't do with a website. Like tisk, tisk, tisk. Yes, you're allowed to visit the website like a normal user, but if you collect a lot of data, you should just infer that the computer owner didn't want that. And so maybe that's an unauthorized access. And so you have these sort of very different theories of what authorization might mean. And for a long, long time, there's just no cases establishing what the answer is. So the answer, for a long time, when we would do sort of panels kind of like this one on various topics of the CFAA, the answer was pretty much always like, yeah, we don't know. We have no idea. No one can tell, because there was just no cases. Finally, we have the US Supreme Court last June deciding Van Buren versus United States, the Supreme Court's first Computer Fraud and Abuse Act case, which lays down some markers here which can help us explain or get some idea as to how the CFAA might apply or not apply to web scraping. Although Van Buren did not apply to web scraping. It was actually one of these employee cases, a government employee who is told you can access this sensitive database only for work-related reasons, and then he does so for personal reasons. He's being paid a bribe actually to look up sensitive information on somebody as part of an undercover FBI sting. And the Supreme Court had to figure out, is that unauthorized access because he violated the workplace rule? And the Supreme Court says that is not unauthorized access. That is still authorized access because he had a username and password to access this database. He was given authorization, and therefore the CFAA is sort of an on-off switch. Like either you have authorization or you don't. He had authorization to access the database, and this express limitation couldn't change that once he had been granted authorization, and therefore this was authorized. The court didn't answer the big picture question of whether the CFAA is only about this authentication circumventing technological restrictions, narrow view, or could also apply to broader concepts. But it leaves a bunch of hints that that's probably where the law should go, but it isn't answered definitively. So we have the US Supreme Court's decision, which kind of informs us, and then we have a bunch of lower court cases on web scraping more directly that we kind of can figure out which one of those are still good law after Van Buren, and that's the kind of puzzle that, from a legal perspective, we're stuck trying to figure out.
So it sounds like that there's some persistent ambiguity, at least as to unauthorized access. We got some answers in Van Buren, but as to data scraping, I mean, it sounds like, at least to me, to the extent the CFAA will touch on data scraping, it'll fall into that norms of what's appropriate bucket that you alluded to earlier, where there's this sort of like, what are you supposed to do when you access a website? Is it okay for you to make a bunch of HTTP calls and collect a bunch of data? Or is that a sort of outside of the realm of what we think a normal website operator would apply? Is that right? Do you think that data scraping falls within this norms bucket, or is there some other question of authorization that will address the scraping question? Perhaps it's terms of service.
Yeah, so I think here's my best sense of the law at this point, which is that if we're talking about scraping and there's been no cease and desist letter sent, so this is just a website that has information and you want to gather the publicly available information, I think that's generally going to be held to be legal. Under Van Buren, it's made available to users, this was the gist of the HiQ Labs, LinkedIn versus HiQ Labs case, although that case was vacated and we're now actually waiting for the Ninth Circuit to consider whether the same result applies after Van Buren. I think it does, but we'll just have to wait and see what the Ninth Circuit says on this case when they hand it down. They rushed to get briefing in, and then they've sat on it for a long time, so we don't quite know what's going on, although it took them a long time to get the first opinion out, so who knows. But I think that's probably going to be legal. The basic norms-based idea, you're just supposed to know, you're not supposed to do that. Courts have generally not adopted that view. And so this goes back to, there was a First Circuit case from 2003 called EF Cultural Travel versus Zephyr. And that involves scraping information off of a pricing website for travel. And so a business competitor of the travel company knew enough about how the website worked to scrape the data off of it and undercut the pricing offered by the company that had the website. And the First Circuit said, we're not going to get into this kind of norms-based reasonable expectations of a website concept. It's just too hard to know how much is enough, especially for a criminal statute, especially, and this is the caveat to it, as the First Circuit says, especially because you could just impose a written restriction that would itself guide authorization. And that's the theory that then Van Buren rejects. Right. So it's you kind of have to figure out, is that First Circuit case still valid law for the first part, or did that reasoning hinge on the second part that Van Buren undercut? We don't really know. But my own sense is that scraping generally, if it's a publicly available website, it's known to the public. As long as that there's no cease and desist letter, and we can talk about the potential impact of cease and desist letters, I think that you're probably in the clear from a Computer Fraud and Abuse Act perspective.
Well, so we have 5 minutes until I'd love to start to turn to audience questions. So I'm going to tell everyone in the audience to start sending those in, and then I'll turn to those. But maybe it's worth taking a few minutes to talk about the cease and desist letter and how that I think maybe one, how it affects the outcome, how it might affect the outcome, and also whether you think, I'd love to know whether you think a cease, to the extent it changes the outcome, whether that's the right process. Is that how we should want to change outcomes, is through cease and desist letters? Or do you think that there's a different or better way to do it?
Yeah, so my own personal take is cease and desist letters are completely irrelevant. I mean, go ahead, have your lawyer send a cute little letter on the lawyer stationery, and ooh, wow, a cease and desist letter. Like why a cease and desist letter should matter? All it does is indicate that the computer owner does not want you to do the thing. But I think the CFAA is about the technology of what the computer owner has allowed, not what the computer owner's preferences are. So the clarity of expression in a CFA in a cease and desist letter, I think makes no difference. Now, what the courts have struggled with this, and basically we're talking about Ninth Circuit law. There was an initial case, Facebook versus Power Ventures, involving a company, power.com, that had a website that aggregated social media sites. So you'd have your Twitter and your Facebook, and it would get the permission of the users to take the information from those sites and pipe them to power.com. And then you would just, as the user, you'd see all of your social media accounts from power.com. And Facebook didn't like this one bit, because of course they sell advertisements for visiting Facebook, and they don't get that if you're just having the information sent somewhere else. So Facebook sent a cease and desist letter saying, you can't do this, this violates our terms of service. And then that led to litigation in the Ninth Circuit about whether the Computer Fraud and Abuse Act allowed Power Ventures to nonetheless access Facebook with the permission of the users after receiving the cease and desist letter. And then to make it extra complicated, there was in the HiQ Labs versus LinkedIn case that we talked about, there was also a cease and desist letter, but that was publicly available webpage. That was LinkedIn's information that you don't need a LinkedIn account to access. And the Ninth Circuit in the first case said that the cease and desist letter withdrew authorization, and it was a violation of the Computer Fraud and Abuse Act after receiving the cease and desist letter to access the account. And then in the second case, the HiQ Labs case, which remember was vacated, the non-lawyers are like, getting complicated. Even the lawyers are probably having that reaction, said, well, that was because it was a code protected website, and with a publicly open website where it's just available to the public, the cease and desist letter doesn't matter. So the cease and desist letter makes it more complicated because of this Facebook versus Power Ventures decision. But we don't know if Facebook versus Power Ventures is still valid law in the Ninth Circuit after Van Buren. We'll find out hopefully when the Ninth Circuit hands down HiQ Labs, but that just hasn't happened yet.
Okay, so we've talked about Van Buren, we've talked about HiQ, we've talked about Facebook versus Power Ventures, EF Cultural Travel versus Zephyr. Maybe it's worth it for you to take a few minutes and tell us, for lawyers and non-lawyers alike, what are the 3 most important precedents in this space Like if you were assigning a seminar for one class, what are the three classes, what are the three cases you might assign? And then also, what are the three cases that we should watch going forward that you think are the ones that are still percolating through the courts that are going to change the way we think about the CFAA?
Yeah, so the three big cases I think are pretty much the ones we've talked about. So it's going to be Van Buren, just because it's the one Supreme Court case and it was hot off the presses. So any litigation about the CFAA is gonna really mine the precise reasoning of Van Buren, which is, it's complicated what the reasoning is of that decision, and there's sort of a little bit for everyone that can be taken for litigation going forward. But Van Buren is the big one, and then for web scraping in particular, I think it would be HiQ Labs, even the vacated opinion. That there's a lot in there that I think other courts would be interested in, and it's not currently the law of the Ninth Circuit. It's not binding precedent, but there's a lot of guidance in there nonetheless. And the Facebook versus Power Ventures is probably also a good place to start. There have been a couple of really interesting scraping decisions that scraping cases that didn't lead to decisions. So United States versus Arenheimer from, I think it was 2014, was a case involving scraping information off of AT&T's website that was at URLs that AT&T thought would not be discovered, and AT&T had put information, email addresses at those URLs. And Arenheimer, I should say my client, I represented Arenheimer in the Third Circuit, was charged with violating the CFAA and convicted, at least at trial, for violating the CFAA on the theory that it was it's basically the reasonable expectations idea from Zephyr that was rejected in the Zephyr case. The Third Circuit then vacated the conviction without reaching the unauthorized access issue. So that's a great set of facts, but then ultimately, excuse me, no ruling. And so in terms of cases to watch, as we mentioned, LinkedIn versus HiQ Labs is really the big one. There's also a very interesting district court case that I think is worth flagging, Vox Marketing Group versus Prodigy Promos, which was handed down by Judge Nielsen in the District of Utah last year. And that involved pricing information that a company had made available on the web. They thought, and basically whenever they had orders, they would post their orders at a URL, and they thought that it was password protected. It originally designed to be password protected. So only the recipient of the order, at least as I understand the record, only the recipient of the order would receive, would be able to see the order, and it would show up on the URL. At some point, as I understand the record, the password protection became disabled. And then the competitor company saw that and was able to access the order information just by visiting the public website address. And in that case, Judge Nielsen said that it was an unauthorized access because it was essentially bypassing a password gate, even though there was no password gate. It was sort of like, I think he analogized it to like rattling a door that is left open and then seeing it's open and going in. I'm not persuaded by that analogy myself, but that was at least that district court opinion. And we'll see. I don't know if that's going to lead to more litigation, but that's one that is worth watching.
Okay. I'm going to start turning to audience questions. So there'll be less of there may be less of a conversational flow, but that also is your cue, audience, to start sending questions in. I'm gonna start with the one that I think has the most votes so far, but I may be miscounting. So this is a question about the difference between websites and apps. So it's maybe a little bit in the weeds, but essentially the question says, look, most apps use APIs that connect with website backends. And so what happens if you are pretending to be an app, you're spoofing an app to access the API to get access to this information? Is that a CFAA violation? I would think, given the way Van Buren comes out, the answer is no, because the API gives you technological access, and this is a sort of written restriction on your access. So you have to be an app, a duly authorized app. But I'm wondering if you have a take.
Yeah, I guess I want to know a little bit more about how the technology works. So this is information that the website is making available to anybody who queries the website on the theory that it's supposed to be a legitimate app there's no authentication or anything. It's sort of everybody can access it without any authentication. Is that how it works?
That's how I read the question. That's my assumption.
Okay. Yeah, I mean, I guess I would say that as long as it's something where it's configured such that anyone without any authentication, any account information is able to query that, then that is totally then that should be fine. It's no different from a website. It shouldn't matter whether it's, in a URL line versus something that is made available to everyone. I don't think that makes a particular difference. But if it's where things get tricky is if there is some sort of authentication mechanism of a particular account or something like that, and if the spoofing is of the actual account holder, then that's a different case. I think then you're dealing with a more complicated case probably that comes out the other way. But and I should flag for those of you that like reading law review articles in your free time, and who doesn't. I had an article in 2016 called "The Norms of Computer Trespass" that tried to figure out sort of where are all these lines, because I think it's really hard. And the reason why it's hard, I think, is that we traditionally with concepts of trespass law, and the CFAA is really like a computer trespass law. The notion of the computer trespass of the physical trespass is often quite intuitive. It's like you just are supposed to know you're not supposed to do that. You're supposed to know you're not supposed to go into the back room. You can go into the front room of the store when it's open. You can't go into the back room, even if there's no sign saying you can't do it. You're supposed to know it, and everybody does know it. So we all kind of have an idea of what trespass is in the physical world, and then in the computer setting, trying to figure out what equivalent norms are is actually hard, and courts are trying to struggle with it. So the question reminds me of those sorts of puzzles that I tried to shed at least a little bit of light on in that article.
That's a nice analogy, and I think it leads nicely into the next question I want to ask from Professor Hufnagel. So, he asks, how do we talk to companies about protecting their data? So, given the sort of lack of clear norms about you don't enter the back room of the store, but maybe you do interrogate the back end of a website. How should we talk to companies about protecting this data, particularly in an environment where we want, or web developers or web companies may want there to be, apps or other applications that are layered on top of whatever platform they're providing?
Yeah, so I take this question to be like not a legal question, but how do you explain the risk to the companies? And here I think this is I think really important, because from a company standpoint, you don't care technically where the law is, or at least where the law is one little piece of this. I think most of the time from the company standpoint, presumably they're worried about like, how do you keep your data secure? And so even if there are arguments that you can use the law to go after people who grab your data, the fact that that's a possible tool should not give you any comfort, especially because the tool itself is really uncertain. The CFAA, is up in the air. And there are other possible causes of action in addition to the CFAA, trespass to chattels or something like that, and a state trespass claim that has been sort of raised as a possible way of making similar claims. But you shouldn't be relying on the law. And so, in addition to arguments about what the law is, just having strong security, not relying on making information sort of broadly available and hoping that limits like, terms of service will help you protect that. Those are really, really weak protections practically, and you shouldn't be relying on those if it's sensitive data. And so that I take to be kind of the technological reality apart from where the law is.
So, I mean, it sounds like from the counseling perspective, a lawyer that's in counseling a company, the one good answer is invest in technological measures, real technological measures that protect your data, rather than terms of service or the CFAA and sort of ex post enforcement against bad actors. Maybe
the analogy is if you live in a neighborhood where there's a lot of crime, your first thought is, you might think, let me get an alarm system, or let me put if you need to, bars in the window or whatever. You don't think like, oh man, I really am glad there's a good, burglary enforcement legal mechanism, and whoever breaks into my house, they're totally going to go to jail. Like that's not your first line of defense. So it shouldn't be in the technological space either, because it's just not an effective way of going.
Yeah. No, that makes a lot of sense. But I mean, it turns out that a lot of companies are not very good at protecting sensitive data. And so I'm going to follow up with another question from Professor Hofnagel, which is a lot of companies not very good at protecting sensitive data. And so, we have these quote unquote white hat hackers that are trying to find vulnerabilities in services in order to alert the service providers to these problems, or publicize these issues so that they can be resolved and sensitive data can be protected. What are the risks to those white hat? I'm not going to use the word hacker. I'm going to say the white hat actors. What are the risks to
the white hat freedom fighters?
Yeah, sure, the white hat freedom fighters. I like that. Like what? How does the CFAA think about them? How should the CFAA think about them? The second part of the question being not a strictly legal one, and more of a policy question. What do you think?
Yeah, so legally, it doesn't matter whether you say you're hacking for good or hacking for bad, right? It's sort of if you're engaging in an unauthorized access, there's no sort of the public good authorized this defense. And so if you want to engage in security testing, you have to get the permission of the computer owner and say, do you mind if I do this? Or let me get your permission expressly to do this. And therefore it's an authorized access if there is access. And so that would be the legal answer. And then the policy answer becomes more a question of which cases are actually going to be prosecuted. And so it's the outside hacker who's going to be more likely to be prosecuted, although the outside hacker usually is not known. And so the biggest challenge with bringing criminal cases against the outside hackers who are doing this for not for sort of security reasons, but for whatever malicious reasons, it's trying to figure out who those people are is the biggest challenge the government has, because it's very easy to conceal identity online. But legally, it's no different from a physical house. Like if I want to show someone it's really easy to break into their house. And I break into their house and then show them, look how easy it was to break into their house. I can say this was for your own good, but they're going to be mad at me, and reasonably so. So I think the law does not recognize this as a justification. It was good for the world, generally speaking. I guess there's a limited necessity defense. Let's not get into that. But so generally, you need to get permission to make it legal. Although prosecution, whether it's prosecuted or not, is a separate question.
Do you want to answer the should question? Should we come up with ways to try to insulate this behavior from liability?
No.
Okay.
Yeah, I mean, I think the problem is, okay, let's say you insulate it from liability. Who gets insulated? Does that insulate anyone? Anyone in the world can hack into anyone else and say, I was doing it for computer security reasons. Yeah. And it's going back to it's totally standard in the computer intrusion cases that are brought, that going back to like the early ones from the 1970s, it was always for a computer security related reason, right? The former employee who hacks in using a username and password of someone else at the company and is caught downloading the valuable software. Well, what do they say? They did it to show the company how easy it would be to steal the valuable software for the company. And so are you going to have a legal system that requires sort of an analysis of whether that's a true answer or a not true answer, and sort of what was in their heart as a matter of law? I think that's a hard thing to do. So legally speaking, I think it's a problem that doesn't strike me as substantially different from a broad policy perspective as trespass in the physical world, and just getting permission is the way to go.
Okay. I think we could probably have a long conversation about that.
Yeah. Why do you think I'm wrong? Go ahead.
I don't know that I think you're wrong. So I guess I have two responses to that. The first is, we inquire into motive quite often in law. And we leave that to juries or judges or fact finders to make that call. And I guess I'm not sure why we shouldn't inquire into motive in this context in particular. So it's true, right? Everyone might throw this up as a defense. Just as in, a criminal case, everyone might say, well, I was acting. It might be common for people to say, well, I was acting in self-defense. And in some cases, that self-defense defense would be reasonable, and in others it wouldn't. And we rely on the fact finders to decide whether or not that's credible. And I'm not sure that we can't do that in the CFAA context also, where we can rely on the fact finders to distinguish between the disgruntled fired employee who is doing this for computer security reasons and the actor that has a history of being a computer security expert and covering these things and making public disclosures. There may be a way, I think, to draw the line. And the question is whether or not the rule is more or less under-inclusive in the cost of that versus how wrong we are or how costly it is to inquire into motive. And I don't have a good handle on which one is empirically cheaper.
I don't understand cheaper in what sense. So
the cost of being wrong versus the cost of doing the inquiry.
The costs society-wide, sort of like,
society-wide.
Let's take a physical world analogy. Like, it's okay for me to break into your house because I'm a white hat trespasser.
Sure.
And so we sort of imagine how much trespass would be in the world if it was generally okay to break into somebody else's home for anyone, as long as they were deemed a good breaker inner.
Yes.
And so we sort of imagine two worlds, one where breaking in is fine as long as you can sort of persuade the powerful prosecutor that not to prosecute you, but prosecute the other person because they're bad. Yeah, I mean, in criminal law, we don't recognize this sort of like, you're a good lawbreaker. Like, it becomes a prosecutorial discretion issue, and certainly that can be a part of it. But I guess I especially given we're talking about a law that ultimately is protecting privacy and is ultimately protecting security, having a rule that your privacy and security is really just up to everyone, whether they want to respect it, as long as they can persuade a jury or a judge that they're good people, strikes me as troublesome.
Yeah, that's persuasive. That makes sense. Yeah. Okay. Turn back to the questions. This is sort of it's a neat small question. What happens in the event? So imagine a site is using a CAPTCHA to try to deter automated scrapers. Now the automated scraper uses some technical method to bypass the CAPTCHA. Is that a CFAA violation? And I want to add to the question, is it a CFAA violation at the level of the CAPTCHA, or is it a CFAA violation at the level of the automated scraping, the access to the data, or does it matter?
My own take on this is that bypassing a CAPTCHA is not a CFAA violation. It's not an unauthorized access, because I think the nature of the CAPTCHA is it's not a block, it's a speed bump. It's kind of like you're still permitted, you just need to come in slowly. And so it's still ultimately authorizing the access, it's just trying to slow it down. And so bypassing it to make it faster is not ultimately keeping, letting somebody in who is supposed to stay out. And so I have, I wrote about this in the Norms of Computer Trespass article, actually. So it's sort of, I have sort of an authentication based normative take on how I think this should play out. I should say this was like my ideal world answer. In terms of how courts would actually answer this, it was we don't actually know. And this came up a little bit in a case, United States versus Lawson in New Jersey, maybe like 10 years ago, 8 years ago. But there was no direct answer to the question because there was a lot else going on in the case. It was a case involving, I think it was like Ticketmaster buying a lot of tickets, and bypassing a CAPTCHA was involved, but there was a lot more to it. And so we don't have a clear answer on that from the cases, at least.
So this is a big question, and the question itself is longer, but I just want to ask the top line part of it, which is, how do we balance this need for privacy or personal security against the desire to use this data for large-scale research projects? Like what's the right balance between that individual privacy and the public good that can come from having access to this data at scale? And how I think the asker, the questioner is asking you, like, how should we strike that balance? And then maybe you can compare what you think the right take is to where the CFAA draws the line.
Yeah, so my own take on this would be that just to have an authentication mechanism where if you want to protect data and protect privacy, you put it behind some sort of an authentication gate, some sort of password requirement, something that says only this group is allowed in and this group has to stay out, and everyone, the public, is allowed to get access to all the stuff that everybody can go to, and only those who have accounts or can be authenticated correctly are allowed into the private stuff. And it's sort of it's like the gate in the digital world. And if you want to keep it private, you put up a gate. That I think is basically the answer. And then that allows the outside the gate stuff to be monitored, and the inside of the gate stuff can't be monitored, and you get sort of private in one area and public in another area. I think normatively that's sort of the best available answer. Although, in terms of where the law is, that's a possible way that the law might go. We're going to have to wait and see. Van Buren had those issues sort of in the case, but then didn't ultimately didn't answer it. They decided the case narrowly in a way that didn't ultimately shed light on that. At least that's my own take. Actually, I'm kind of interested in your take. Do you think that's?
So it's a good question. I don't know. So I'm trying to think. So the way you just described that is a world where a desire to keep data private, so long as you effectuate it, automatically trumps or sort of automatically supersedes any public interest in collecting that data. And as you may have guessed from the conversation we just had like 5 minutes ago, I am more willing, I think, to take a less rules-based approach and a more standards-based approach. So I think I would want to know more about, okay, this data that you want to keep private, why do you want to keep it private? And what's the value of not having it private? And maybe we should do something else with it instead. So I think I am less inclined, I think, to defer automatically to whoever stores the data and their preferences as to whether it's private or public. Now, that's complicated, I think, by what is the data and who does it belong to, like who does it attend to? So it might be that the data is a bunch of really sensitive health data about the population, the American population. And so, maybe in that case, we should keep that data private, even if that health data could be used to make meaningful health advances. But I would say that's not because the health provider wants to keep it private, but because of the privacy interests of the patients. And that requires us maybe engaging in a balance between the privacy interests of the patients and the health advance. And that's a case-by-case examination. What's your reaction to that?
Yeah, to some extent, I think our differences are maybe there's like a civil criminal divide where I'm thinking about it from like a very rules, like, the law has to say what you can and can't do, because if you violate the rule, you can get arrested and taken to jail. And like the penalties in the criminal world are so severe that you want to have like a uniform, bright rule. And that may be kind of explaining where we're coming from different directions on this. So I'm more attracted to the just like bright line, like this is how you protect data. And there are going to be, questions of like account holders. Can the account holders share the information, even if the computer owner doesn't want it? Like shared passwords, there are complicated cases, I think, under any of these rules. But But I think I'm more of a bright line person, probably just coming at it from the criminal law.
Yeah, and that's a nice point. The sort of distinction between the civil, criminal, and the, I wonder if we're being too lawyerly here, but the sort of due process concerns that attend to, criminal liability and the amount of notice that you want before subjecting someone to that criminal liability. Okay, I'm being told that we have time for one lightning round quick question. So maybe I'll turn to the first question that we got that kicked us off. This questioner asks that, I once heard that part of the reason automated web scraping on private sites was illegal is because you are imposing your own code onto their site. Is that right? Is there any truth to that? Does that make sense to you? And then I'll hand it back to Rachel.
I don't think that's right. And there have not been, there were a few very broad lower court Computer Fraud and Abuse Act cases that sort of said everything that the computer doesn't want is a CFAA violation, but I'm not aware of any cases that specifically said it's because you're sending your code there, your code is being inserted there, or anything like that. So I don't think that's right.
Okay. Thank you so much, Orin. This was a lot of fun. I really enjoyed talking with you about this.
Likewise.
I will.
We should get to have more conversations like this.
And not only over Zoom.
Great.
Thanks, Orin. Rachel, back to you.
All right, fantastic. Thank you so much, Tejas and Orin, both of you, for a fantastic discussion. And we really appreciate you joining us today to share your expertise with us on this evolving issue. So before we close, I just want to give a huge thanks to our CLTC supporters, our network of community partners, foundations, as well as our industry partners whose support helps us make events like this possible. And I'm also going to share a few ways that folks can keep in touch with CLTC and our panelists. So if you didn't get your question answered today, or you'd like to follow up with Orin or Tejas, they have kindly provided some of their contact info here. We have a Twitter handle and email address for both gentlemen where you can follow up with them directly. And we also have some CLTC info at the bottom of the screen. So feel free to follow us on Twitter or head to the CLTC website where you can sign up for our newsletter so that you won't miss future events, such as the next conversation in this data scraping series and much more to come from CLTC. So I will leave this slide up for a minute or two in case folks want to jot down any of this information. But that's it from us. Thank you once again to everyone in the audience for joining us today and for engaging and having such a thoughtful conversation. Thank you again, Tejas and Orin. We look forward to seeing everyone next time. Until then, take care.